Welcome to a Practice Pro CPD, brought to you by LAWPRO.
Good morning, everyone. Thank you for joining us. I know we have a few more people who are coming into the room, but it is 9:32, so I am going to start now with a few housekeeping matters. To begin with, I would just like to say that I'm speaking from Toronto, which is also where the offices of LawPro and the Toronto Lawyers Association are located. I respectfully acknowledge that Toronto is on the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat peoples. It is now the home to many First Nations, Inuit, and Métis peoples. Toronto was covered by Treaty 13 with the Mississaugas of the Credit. Now, as this meeting is virtual and we're not all gathered in the same place, I would encourage you to research the traditional territory you are on if you have not already done so, and take some time to learn about the history of it. As a resource, you can visit the website native-lands.ca to search for a location and find the appropriate territory acknowledgement under the Resources tab that applies to your specific area of Ontario or Canada. I'd like to recognize the long history of all First Nations in Ontario and the Métis and Inuit peoples, and we thank the First Nations peoples who lived and continue to live in these lands for sharing them with us in peace. Now, this program is called Family Law in 2025, Managing Risk and Building Your Professional Network. I'm very pleased that you can all join us today. A few housekeeping matters to start us off. You will find both a chat function and a Q&A function as part of this program. They are at the bottom of your screen, most likely. If you have a question, please put it in the Q&A box. We will be answering questions, substantive questions that apply to the program at the end of the program, and we will save some time and be able to put those questions to each of the speakers at the very end. So if you do have a question that comes up about what the speakers are speaking about, please put it in the Q&A box, not the chat box. In the chat box, however, you can find a link to the program materials for today's program that is gathered at practicepro.ca/CPD. Now, if you go to practicepro.ca/CPD, you can also find all of our previous programs. We do about 6 of these every single year in cooperation with the TLA, and they are available on demand to watch through our website, Practice Pro. A few more things to mention here. This is a CPD accredited program and is worth 90 minutes of professionalism. At the end of the program, we will be putting a link to a survey into the chat. Please take a moment to click on that link and fill out the survey. It helps us prepare for what content you would like to see in the future, and also helps us improve these programs and determine what elements you like, what elements you think could be improved, and what elements we should refocus. So please take a moment to do that at the end of the program. One of our speakers, Michael Zalev, is going to be using a survey function as part of his program. I'm going to put the link to that survey into the chat in just a moment here, but he will also be explaining it to you. It is something that you can click on. It is a safe link. I've tried it myself. And when you go to the website, it will allow for some user interaction as part of his presentation. Now, in addition to Michael, we have a lot of excellent speakers lined up for today. We are joined by Susan Sack, who is a founding partner at Rosen Sack, Karen Hagman, who's a lawyer at Malex Litigation, Yvonne Bernstein, who's the litigation director and counsel here at LawPro, and so has firsthand experience in the type of claims that we're seeing with respect to family law. And of course, as I mentioned, Michael Zalev, who's a partner at Epstein Cole. The content we're going to be discussing today is about building your professional network, as well as some risk concerns that we are seeing at LawPro. Yvonne Bernstein is going to start the program in a moment here, talking about what LawPro is seeing, but specifically with respect to repudiation of settlements and contracts and how that interacts potential malpractice claims within the family law realm. Now, Karen Hagman is going to speak after that about building and using a professional network. And then we'll be joined by Michael Zalev, who will be talking about effective client screening and how you can avoid claims by choosing when to say no and when to refer a client elsewhere. And finally, we're going to hear from Susan Sack, who's going to talk to us about providing independent legal advice and how there are risks associated with that, particularly but not exclusively, with respect to drafting those limited retainers. Now, I'd like to ask Yvonne Bernstein to turn on her camera and join us to start the program and talk about what LawPRO is seeing. Hello, Yvonne.
Hello, thank you so much, Sean, and good morning, everybody. Domestic contracts and settlements represent the riskiest components of a family law practice. This morning, I'm going to talk about what the risks are, how to spot them, and how to minimize your exposure to avoid being caught in the crossfire. I'm going to start with domestic contracts. Unfortunately, domestic contracts are highly prone to challenge and do not always stand the test of time. And even more regrettably, when they are challenged, attention inevitably turns to the lawyers involved in negotiating and drafting the contract. The starting point when we talk about domestic contracts and challenges to domestic contracts is Section 56(4) of the Family Law Act, which provides as follows. A court may, note it's permissive, not mandatory, set aside a domestic contract or a provision in it, A, if a party failed to disclose to the other significant assets, significant debts, or other liabilities existing when the contract was made, B, if a party did not understand the nature or consequences of the contract, and C, or otherwise in accordance with the law of contract. So all contractual principles with respect to formation and setting aside of contracts apply in addition to the specific enumerated provisions in Section 56. Note also Section 56(7) of the FLA, which provides that subsection 4, which I just read to you, applies despite any agreement to the contrary. So you cannot contract out of those potential remedies to set aside a contract. Landmark cases such as Levan and Levan, which if you're interested in reading, and I recommend that you read it if you haven't already read it, can be found on Canley at 2006 Canley 31020, and the Court of Appeal decision can be found at 2008 ONCA 388. So these cases help us appreciate how and when Section 56 is applied and the consequences to the parties when a contract is challenged. Contracts which are susceptible to being challenged have common characteristics. They are red flags that you need to be on the alert for. And some of the most frequently encountered red flags are the following. Number one, financial disclosure. Failure to provide disclosure or providing incomplete, inaccurate, or misleading disclosure, whether with respect to income, assets, liabilities, or all of the above. Bear in mind that proper disclosure includes the values of enumerated assets and liabilities. Number two, the second red flag, inaccurate or misleading information about the intent or scope of the agreement. And this arises most frequently in the context of cohabitation and marriage contracts. Third red flag, time pressures. Starting the process of negotiation and contract formation too close to a very critical deadline. And the most common deadlines would be, for example, an imminent real estate closing or a wedding date. Next, a contract that overreaches. Examples would include where the scope of the contract is broader than it needs to be to meet the client's stated objectives, where income from excluded property is removed from consideration in determining support, so that minimal or no support will be payable, even though there is tremendous disparity in the incomes of the parties, and no flexibility in the contract terms based on the length of the relationship or marriage. Next red flag, efforts to negotiate better terms on behalf of the other party are immediately shut down and rebuffed. There's no room for negotiation. These red flags and so many more, which you can find if you look at the Levan case that I mentioned, are a critical checklist of what to do and what not to do if you are acting for either party to the contract. If you spot one or more red flags, don't ignore them because they spell trouble for your client and potentially for you as well. The red flags also help you educate your clients about the process, about their rights and obligations, and show them what can go wrong if they overreach and try to get too good a bargain. How many red flags will tip the scales against a contract? Which flags are the most important? I would say that the obligation to make complete, fair, and frank disclosure is paramount. And that is the case regardless of whether the other side asks for it or not. But bear in mind that every case turns on its own facts. And while the outcome may be uncertain, you can safely assume that where there are red flags, there will be a challenge, and the lawyers who acted on the contract are likely to be involved. What is the takeaway from all this? Simply this: it is only reasonable to rely on a contract which meets the requirements under the Family Law Act as interpreted by cases such as Levan. A contract which does not meet the requirements is not worth the paper it is written on. And the further the contract departs from the statutory scheme under the Family Law Act, the more closely it will be scrutinized and the greater the risk that it will be challenged. And the second takeaway for lawyers who provide independent legal advice: don't take that type of retainer casually. Don't provide independent legal advice in a non-business setting, such as a restaurant, a bar, at a social gathering, etc. You cannot give proper, meaningful, independent legal advice in a brief meeting. Independent legal advice has to mean something more than reading a contract to the party and asking if they understand and consent to its terms. You need to inquire as to the circumstances surrounding the agreement and advise your client of their legal rights and obligations and the consequences associated with entering or not entering into the agreement. And you can't give that kind of advice in the absence of full disclosure and an understanding of the history, issues, and goals of the parties. Ignoring the red flags and takeaways is an invitation to a claim. And for another example of what can go wrong with a marriage contract, take a look at a reported decision called Martin and Sansome, which is found at 2014 ONCA 14 in Canley. And Michael Zaliv tried valiantly to help Mr. Martin on the appeal, but unfortunately, those efforts were not entirely successful. Lawyers are in the line of fire in these cases, sometimes as witnesses in the subsequent challenge to the contract, and sometimes as defendants in a negligence action. What do you do if a client insists on proceeding with a contract without seeking or providing financial disclosure, or you believe the bargain is unfair and extremely one-sided? What are the options? Well, ignoring the problem is not an option. Basically, your options are to terminate the retainer or complete the retainer, but ensure you have protected yourself and try to educate your client as much as possible. For example, have the client sign an acknowledgement detailing the advice you gave, their refusal to accept the advice, and their instructions to complete the agreement, notwithstanding your advice and all of the warnings that you have provided. The first sign of trouble with respect to a domestic contract may manifest itself years after the agreement has been entered into, and it often starts with a request for production of your file or a request to interview you. Before you do anything, please report the matter to LAWPRO. We will come back to this towards the end of this presentation. Let's talk about drafting errors in domestic contracts. We often see errors in the drafting of contracts, which may involve, for example, an inconsistency from one provision to another provision in a different paragraph. Common is inconsistent terms with respect to variation between various sections of the agreement, or gaps in the agreement. For example, confusion with respect to dates, which leaves a gap for the payment of support. Sometimes they're missing schedules, which should be attached to the agreement. So before the agreement is finalized, review it against a checklist to make sure everything is there and the terms are consistent, and evaluate whether the contract achieves what was actually intended. And don't forget, ensure that the contract complies with Section 55(1) of the Family Law Act, which provides that the contract must be in writing, signed by the parties, and their signatures witnessed. Let's talk about settlements. The most common issue with respect to settlements is the all too frequent scenario of clients who seek to resile from the bargain they willingly entered into. For an illustration of this type of phenomenon, take a look at a recent case called Arbuckle, Arbuckle, and Arbuckle, which you can find on Canley at 2023 ONCA 80. Clients who seek to resile from a settlement often allege a lack of understanding that the settlement was final, or they claim they were pressured, they were under duress, they were not properly advised, or they did not have sufficient information. How can you prevent this from happening? First, before going into a mediation or a settlement meeting, spend time educating your clients so they understand the process and they understand that if a settlement is reached, it is going to be a final settlement. If they don't want a final settlement and they need time, consider whether a cooling off period is appropriate. I know that there are differing views with respect to whether a cooling off period is a good thing or not, but it may be appropriate in some of these situations, and it is certainly an option that should be considered with your client. Another scenario that we see with respect to domestic contracts and settlements is the problem of a mistake in the drafting of the contract or the terms of the settlement. The critical question is going to be whether the mistake was so fundamental to the formation of the contract or settlement as to render it void or voidable, and whether the mistake was detected or detectable and not clarified. This is very important to keep in mind in situations where a party seeks to take advantage of the other side's mistake. Lack of consensus ad item on a fundamental term negates the formation of a contract or agreement between the parties. Equitable relief may be granted where a party, knowing of the other spouse's mistake as to the terms of the offer, remains silent and concludes a contract on the mistaken terms. The spouse need not necessarily prove actual knowledge on the part of the other party if the circumstances are such that the mistake would have been obvious to a reasonable person in that situation. Equitable relief may also be granted if a party should have known of the spouse's mistake. 2, where the party had an indication that the spouse was entering into the contract under a misapprehension as to a fundamental term and either proceeds on a course of willful ignorance designed to inhibit their own knowledge of the other side's mistake, or deliberately sets out to ensure the spouse does not become aware of the mistake. For an example of this type of situation, take a look at a relatively recent case called Banerjee, BANERJEE, and Mathoo, MATHOO, which you can find at 2020 ONSC 1606 in Canley. In this case, the court found that the settlement contained a mistake of which the respondent was either aware or turned a blind eye to. At the very least, a reasonable person in the context of these negotiations would have made some inquiry before rapidly accepting an offer to settle. And bear in mind that evidence of a mistake is an important consideration in the exercise of a court's discretion to enforce a settlement. The takeaway: you cannot turn a blind eye to the issue and accept the agreement or offer if there is a mistake. In these situations, there is a positive duty to inquire with the other side and to obtain clarification. Failure to do that will result in litigation, and the party seeking to take advantage of the error will most likely not be successful. So if your client is insisting that you accept the offer, even though you believe there is ambiguity or a likely mistake, make sure your client understands the consequences. Do not promote this type of situation or become part of the problem. A common theme we hear in many claims that are reported to us, whether it's dealing with an oppressive domestic contract, lack of disclosure, an attempt to take advantage of a situation, or pushing for a settlement, is the mantra, "This is what the client wanted, this is what I was instructed by my client to do." It's critical to educate clients and to manage their expectations. You need to help clients understand that a bad contract truly is not worth the paper it is written on, that it does not pay to take advantage of a mistake, and that an agreement has to be properly structured and entered into in order to be binding. What do you do if you become aware of a problem? First and foremost, please report to LAWPRO immediately. Be aware of your obligations under the policy. Under the terms of the policy of insurance, you are required to report any circumstances of an alleged, actual, or possible error, omission, or negligent act of which you become aware, which from the perspective of a reasonable lawyer could potentially give rise to a claim. So circumstances include questions about your retainer, a request for production of your file, a request to interview you, to have you provide evidence, to be a witness at trial, etc. All or any of the above give rise to a duty to report. Your other obligations under the policy are to cooperate with LAWPRO in the investigation or defense of a claim or circumstance. Do not voluntarily assume any liability or try to enter into a settlement with your former client. Be aware that failure to report promptly can potentially result in a denial of coverage if there is prejudice to the insurer. Be aware also that the professional liability policy, like all such policies, is a claims-made policy. So if you report a claim that you become aware of for the first time today, regardless of when the error took place, it is today's policy which will respond. And last but not least, know the limits of your policy. It's a 1 million limit for practicing lawyers. And if you leave practice, the mandatory amount that you have, subject to your rights to buy up, is $250,000. Sean is back on the screen, which means my time is up. So I want to thank you for your attention, and over to you, Sean.
Thank you so much, Yvonne. And we did put the case citations for the cases that Yvonne discussed during her presentation in the chat. So if you missed that, you can please scroll up through the chat to find the links to the Canley decisions that Yvonne discussed. And as well as mentioned previously, the program materials themselves are also available through a link in the chat. So if you can't see it right now, just scroll up and it'll be one of the previous things that was mentioned. One other thing, just remember to please put your questions into the Q&A. We are tracking them. We already have some questions and we will answer those at the end of the program. I'd like to ask Karen Hagman to join us now. And Karen is going to talk to us about building and using your professional network. Karen?
Thanks, Sean. Good morning, everyone. So today I will be speaking on the widespread issue of family lawyers in Ontario practicing without mentors or networks that they can rely on to answer practice questions. Before I dive into it, just some more background about myself. I'm a lawyer at Malex Litigation. We have offices in Toronto, Hamilton, and Thunder Bay. I live and work out of Thunder Bay, where I am joining you from this morning. I have a mixed practice of private files in the areas of estates, trusts, and capacity litigation, as well as I'm preferred counsel for LAWPRO in the areas of estates and family law. I practiced family law for the first 5 years of my practice, and the overlap between family law and estate issues is what led me to where I find myself in practice today. I started my practice in a mid-sized firm where I was fortunate to have mentorship from a senior and very well-respected lawyer of the Thunder Bay Bar. He always encouraged me to pursue opportunities to help build my network of people, opportunities like networking or attending CPD events, speaking engagements, or community volunteering. I met the founding lawyer of my current firm as opposing counsel on a file. It was a pretty contentious file, and our clients were basically on completely different planets. Although we were on opposite teams at the time, we were able to work together to find a way forward on the file. And now we're colleagues. And our approach to practice is very collaborative. We review each other's draft documents before they get issued by the court or before we send them to a client to review. And the lawyers in our office meet on a weekly basis to talk out issues on files, or if we have a client issue or practice management issues, that's a time where we all come together to discuss those things. And the mentor in the firm that I started out in after all of these years is still there and still is in my network of support. So all of that to say is building your network of support can really come in all shapes and sizes. We're not alone in practice. We should never feel alone. Even if you're a sole practitioner, or maybe you're in a small firm where you're one of a handful of family law lawyers, or maybe you don't have the mentorship in the firm that you're at, there are lawyers and resources out there to tap into. What I hope to provide today is some practical advice and tips on how you can build your network with the view of developing mentor or colleague relationships that can be used for things like contingency planning, someone to call for advice, or general family law support. The main takeaway of anything from my presentation is to be intentional. Relationships are really the key to developing meaningful connections with other lawyers and legal professionals. And we hear it all the time, and I think it's worth repeating. Your reputation means everything. And having trusted colleagues or mentors that you can turn to is crucial in this line of work. And having that support really will help you sleep at night. So I want to start by touching on maybe some of the less obvious ways to build your network of support and some things that have helped me in my practice and continue to help me in my practice. And I think the best way to do this is by way of example. So first, let's say you have a new file and you need to give the client some advice on what claims they might have. You're doing some research and you find a case that is similar to yours, or maybe you find a blog post or a LinkedIn post that touches on the topic that you're researching. My suggestion is send an email or pick up the phone. Contact the lawyer that was on that case or on that blog post. Even if you kind of already know the answer and you just want some confirmation that you're headed in the right direction, reach out. Not only do you get some peace of mind talking out a file with another lawyer, it's really an opportunity to establish a connection in a very easy and informal way. I've done this myself many times. Even where I have had mentorship in the office, sometimes someone is in the middle of prepping for a big hearing, or maybe someone's not really around at the time to talk out an issue. I find that other lawyers are usually very happy to talk about their cases. They want to pay it forward. And I find that this is a really small but effective way of reaching out for support when needed, and a good opportunity to introduce yourself. This also applies to precedents. I've done this myself and I've had other lawyers reach out. They say, hey, I read your case. Would you mind sending me your factum? I have an issue that's exactly on point. And again, this is a small but effective way of sharing information which can open the door for ongoing advice. Another less formal way of developing your network is by joining a study group. And this is something I have joined recently myself. The idea in my case is that a small group of lawyers of around relatively the same year of call all meet on a monthly basis over the lunch hour on Zoom. Someone volunteers to chair the meeting in advance and will cover a topic of their choice. Topics can range from substantive issues in law or practice management questions. For example, we've had study group meetings where we have discussed the use of AI in our practice, or we've had lawyers come in with a handful of questions they might have dealing with on a file, or client issues. And usually what we find in this setting is someone in the group has usually dealt with an issue that is brought up and they can send a precedent or a case, or there might be a contact they might be able to suggest you reach out to. So a study group sounds like a fine idea, but how do you join one, or how do you create one? All it really takes is one person to take the initiative to form a study group. Think of lawyers you've worked on files with, lawyers from other firms, somebody you went to law school with, somebody that you think might be interested and want to contribute. In my case, and I can't take credit for setting up this group, but I was invited as an early member, so I was involved in shaping how we move forward. And what we did was we thought of a diverse group of lawyers that we thought could contribute a variety of different perspectives. So we have lawyers from Bay Street firms, we have solo practitioners, we have people in Toronto, we have people in smaller communities. We're a group of about 5 to 10. And what I would say is, if you want to get involved in something like this, is to reach out to people and, as a first point of contact, schedule a call or a Zoom meeting and talk about how you want to form the group or structure things. If you're not sure who to reach out to, or if you don't want to take the lead in forming a study group but are interested in joining one, you can post on LinkedIn, you can join one of the Facebook groups. I know there's an Ontario Family Lawyers Facebook group. You could tap into those social media networks. With Zoom, we're more connected than ever, and take advantage of it. A study group is a great way to learn from your peers in a very informal and conversational environment. And I think what you will find is that everyone, whether you're in Toronto or Thunder Bay or elsewhere, we all have the same issues on files. We all have similar struggles in the practice of law. So I think this is a really fantastic way to make new lawyer friends, and then they become trusted colleagues that you can rely on. The cherry on top is that study groups can also count towards your CPD hours. And just a quick side note on the Facebook comment, I think that's another good way of sharing information or asking questions and developing contacts. Even if you have no intention of posting, sometimes the questions or posts that are circulated will be relevant to a file you're on. And it's a good way to see who's contributing to any given topic. You might want to make a note of who to reach out in the future if you need to seek some advice. So I want to shift gears and talk about maybe some more of the obvious ways of, or the obvious networking strategies we have all heard that are sort of the go-tos. Things like attending in-person CPD events or the larger networking events. But what I want to focus on is how you can make the most of these events, not just simply attending and making those superficial connections, but how you can really use these events as an opportunity to make connections with the view of building mentorship-like relationships. So let's say you attend the Family Law Summit, where whether it be in person or online, how do you attend a big CPD event like that with the view of growing your network for mentorship or support? It's really not that hard. I think whether you're in person or online, if there's a speaker or a panelist that is talking on a subject that you're interested in, or maybe it resonates with an issue you're having on a file, all it takes is really just a short introduction saying, I attended your program on emerging child support trends, or I attended your program on compassion, fatigue, and family law. I would really be interested in hearing more about that, or I have some questions about a file I'm working on. Do you have time for coffee or a phone call, or even a quick virtual coffee to check in and have a discussion? We all know everyone's busy, so I think if you can tap into that virtual accessibility, sometimes that can really help in establishing a connection. So now you've turned that big CPD or networking event into something useful and more personal. Another good way to grow your network is to join your local law association or other professional associations like the Ontario Bar Association or the Advocate Society. They usually have practice groups or executive committees that you can join. They will have writing opportunities or speaking engagements that you can also volunteer for. I think putting yourself out there and your knowledge out there is a good way to effectively market yourself. And you might want to also consider participating in some of the advocacy training programs that they offer. For example, a mock trial. I see Sean on the screen, so I will wrap this up with one final takeaway is don't be afraid of being embarrassed. Don't be afraid to ask questions. It's okay to ask questions or flounder at a mock trial. We've all been there. The only way to get better is to make use of what resources are available to us. It's better to ask the hard questions to a colleague or mess up a mock trial than try to compensate for it in court or in front of your clients. So with all that being said, I'm happy to answer any questions at the end of the program, and please feel free to reach out if you ever have any questions. Thank you.
Thank you, Karen, so much. So if you go to the program materials for today's program, which can be found at practicepro.ca/CPD or in the chat does reboot if you leave the room and come back. So we will repost it periodically if you don't see it at the moment. But in those program materials, you can find LawPro's mentoring chart, which does produce some contact information for groups that lawyers can contact to find mentors or to find like-minded or like-situated lawyers to kind of develop those program materials. As well, the TLA has put in the chat a link to the TLA's own family law meetup groups, which is another opportunity, albeit in Toronto, to have lawyers meet up. Local law associations across Ontario do create their own meetup groups in the same regard. So I encourage everyone to look into their own local law association to find those opportunities. Now, I would like to ask Michael to join us. Michael Zalif is going to talk to us about referring clients elsewhere and screening clients. And he is also going to be using a survey, as I mentioned at the beginning. I have put the survey link in the chat along with the username that Michael will be using. He will also explain it himself, all the instructions. So please join us now, Michael, and we all look forward to hearing what you're going to say.
Thanks, Sean. I'm going to share my screen. Hopefully I don't mess this up. You should all be able to see the slide. I'm going to be talking to you about screening clients and cases that come into your office, and really how to avoid doing it ineffectively, or to use the words of one of today's most prominent philosophers, "The blame is on me. I knew you were trouble when you walked in." Taylor Swift. I've felt this way more times than I can count in my practice. When I've had to deal with a liability issue on one of my own cases or had a falling out with a client, it's literally almost always been on matters where I had a bad feeling about things early on, but I pushed those feelings aside, took the retainer when I shouldn't have, or kept acting for a client when I knew I should have ended the retainer much earlier than I did, but I didn't. So what I'd like to do today is to try to give you some tips to minimize the risk that you can find yourself in these types of situations, so that you can minimize the risk of a claim or a law society complaint. And second, this work is very stressful, okay? It's for everybody. You don't need to make things worse for yourself by taking on clients who will blame you when things don't go their way and be unwilling to pay you, or take on cases that you are not comfortable with and that cause you additional stress and anxiety that you really don't need. So Sean mentioned the poll. If you can go to the website, if you have a phone or open another web browser, go to pollev.com. The link is in the slide. You should see a screen that looks like this, and it should ask you for your name. Feel free to be anonymous if you want. Use your real name or just press skip. And you should now see this screen. Okay, so I'm going to just switch the screen that I'm sharing. Bear with me 1 second. You should now see a survey screen. And I see that you do because people are answering the survey. And I just thought we'd get a bit of information about who's here. I have a guess about what the result's going to look like. We will give it another couple seconds. Well, so this shows we've got 50 responses. They're still coming. Okay, well, we can let them keep coming. Let's see. So we can see what the results are. Okay, so we've got the vast majority of people are in a firm with 1 to 3 lawyers, a couple of people in bigger firms. So this is what I thought it would show. It would show that most people are on their own or in a very small shop. And there. So Do you feel comfortable dealing with cases involving any of the following issues? And you can check all the ones that apply to you. Okay, so most people are terrified of bankruptcy, so this doesn't surprise me. Conflicts, a little more. Oh, here comes some bankruptcy. People are comfortable with estates. People are comfortable with pensions. And then a lot of people aren't comfortable with some of these other things. These are issues that come up in family law that eventually you're going to come across. And we'll talk about this a bit more in a little bit. But I'm not, bankruptcy is an especially important one to have some understanding of. Do you have clients sign a written retainer agreement? Got a lot of responses. Always, excellent. Okay. For whoever clicked rarely or never, if you're in private practice and have private clients, you should really make sure you change that. But that's excellent. Whoops. Have you ever accepted a retainer you later regretted taking? I suspect the answer is going to be overwhelmingly in one way. I'm surprised there's even anybody that's never done this, but not surprising. Why did you regret taking the retainer? You can click all the ones that apply.
Michael, just a quick note. I don't believe we can see your screen at the moment. I believe people can see this survey through their own screen if they're using it, but if you are hoping to
Can you
share
see
your
the
screen,
result? You guys can't see the results?
I believe people can see it on their own screens, but
let me,
there you go.
There we go. Okay. So client was difficult is the biggest one for why did you regret taking it? Client wouldn't pay is number 2. An opposing party was difficult. These are all, fortunately, not a lot of people have said you felt well, not fortunately. The fact is not a lot of people said you lacked the necessary knowledge and expertise, but these are the typical problems we see. Non-payment and the client being difficult being the top 2 responses here. And finally, oh, sorry, this one. Has a file that you regretted taking ever caused you stress and anxiety to the point that it interfered with your activities of daily living? So it keeps you up at night. You can't eat. I hear this a lot from lawyers when I act for them for LAWPRO. So just curious. I suspect. All right. So those of you who have this problem are not alone. Okay. I really keep that in mind. This happens to most of us. It happens to me. Okay, so let me just stop the share and exit the poll. Let me go back to my other screen. Okay, so we're going to talk. Sean, I may need a couple minutes because that took a bit longer than I wanted, but I will try to skip through some stuff. So this is what I'm going to talk about briefly because you could talk about each of these things for a long time. But I do want just a quick note about the pictures. I've been playing around with AI a lot. So the pictures to come are what ChatGPT thinks Canadian lawyers look like. Apparently they think we all walk around with Canadian flags and maple leaves all over the place. So just so you understand why the pictures look like that. So getting the full story, separating fact from fiction. There's 4 chances to do this before you take on the retainer, to make sure you know what you're getting into, to make sure the client is an appropriate client for you, and that you aren't taking on a mess that is going to cause you more anxiety than you already have. So first thing is you do your conflict search. And I rarely Google clients after I've just based on the conflict search, because we have somebody in the office that gets the names, and we run the conflict search. Occasionally I've done it. Occasionally I've checked Canly, because that's your first opportunity to get out. You might just say at that point, if you realize this is a case that's been going on for 10 years and there's 25 reported decisions on Canly, you may just say, not for me, I can't go further. After that, you can do the same thing again at the intake process. So different offices will do things differently. I'm fortunate at a larger office, we have a staff member that handles our intake process. They call the client, they get information about, were they married? What are the relevant dates? Do they have kids? Where they are in the process, all the basic information, and they write it down on a sheet for us. And that helps us vet the clients. We also tell the clients about fees and we don't offer at my office free consultations. So we make it clear up front that there's a cost to the consultation and what the lawyer's initial retainer requirement is going to be if they want to go further. And we do that to start assessing very, very early on whether the client's a good fit before we meet, and to weed out cases that aren't good fits. So we're looking at things like, can the potential client afford the lawyer they want to consult with? Can they afford the retainer? Does the client case involve issues that are either beyond the lawyer's expertise or involve issues the lawyer just doesn't want to deal with? Some cases, parental alienation cases can be interesting, but they can take over your life, and you may not want to take on that case, or you may not want to take on a case that's going to end in a 3-week custody trial. And that's fine. If you don't want to do that work, you don't have to, but don't have the client in for a consultation, charge them money that they're not going to get back, and then refuse to accept the retainer. Are there urgent issues that are you won't be able to accommodate the scheduling issues? Has the client been represented by, I'd say, 3 or more lawyers? Okay. Actually, if they've been represented by 2 or more lawyers before they come to you, it's a big red flag. But once you get up to 3, you're asking for trouble. Okay. If you do decide to proceed with the consultation, this is your first opportunity to get information and assess whether there's a fit, and look for red flags. Okay. You also obviously have to do your job, make sure the client understands the issue, the legal issues and the potential limitation periods, and the risk of not changing wills and powers of attorneys and beneficiary designations and things like that you ought to be covering in your initial consult, so the client can't come back later and say they didn't understand these things. But really what you want to do is make sure you can have a working relationship with this person. Okay. And that, if you get that feeling in the back of your head that there's a problem here, this doesn't add up, I don't feel comfortable. There's lots of work out there. You don't need to take everything that comes in the door, and it's totally fine to not accept a retainer after you've had the consultation. And finally, I was glad to see the vast majority of people always have a retainer agreement in place. That is there not only for the client, it is there to protect you. Okay. It should set out the scope of the work you're being done, the fee arrangements, the terms on which you can end the solicitor-client relationship. If you don't have a good retainer agreement or want to check yours against the usual precedent, there is a family law retainer agreement available on Practice Pro's website. Spotting the issues, because clients don't know what matters. This is another one where apparently ChatGPT thinks we wear Canadian flags. When I started practicing in 2006, I found issue spotting one of the hardest things to do. Clients want to tell us everything. They have no idea what's relevant and what's not. And a significant chunk of what they want to tell us is irrelevant, at least legally. And in family law, there's so many issues that can come up, and it's hard to know what the right answer is, what matters, what doesn't, and how to deal with them. One thing that's helped me, it's very basic, but I just split everything into the 3 major categories: property, support, and parenting. And then once I've done that, I can start drilling down on what the real issues are and what the range of realistic outcomes might be, and how those issues can be resolved in an efficient and cost-effective manner. If the parties are both T Ford employees making $50,000 to $75,000 a year and renting a house, and they don't have any savings, it's not a big money case. It's not something you're going to spend, you can sort of wipe that out pretty quickly. You can get a sense of where it's going to land pretty quickly on the money issues. There may be other issues, but it's pretty straightforward on the finances. The other thing I would say is that even though I've been doing this for almost 20 years, I still spend a lot of time thinking about and analyzing the issues in my cases. I still come across issues I've never come across and don't know the answer to. And I still spend a lot of time reading and researching and educating myself so that I can do this work. Okay. It's not a static job. You have to keep up with what's going on, and you will literally be learning new stuff all the time. It becomes much less of that as you get older and as you've done this longer. But at the beginning, everything is new and it requires educating yourself. And in fairness to your clients who are paying, fairly significant amounts of money, you got to be careful about, am I going to charge my clients for, learning the law that I ought to know or that I'm going to need to know now? Like you got to be cognizant of that. They don't need to, if you don't know how to do something, they don't necessarily need to pay you for hours for you to figure it out. Or at least they'll get upset if you do in some cases. So now, for those of you too young to remember, this is a paraphrase of a quote from Donald Rumsfeld, who was the Secretary of Defense when the U.S. invaded Iraq in 2003. And about a year before the invasion, he was asked about the lack of evidence linking the government of Iraq to weapons of mass destruction. And this is the paraphrased version of the fascinating answer he gave. Okay? There are known knowns. There are things we know that we know. There are known unknowns. That is to say, there are things that we know we don't know, but there are also unknown unknowns. There are things we do not know and we don't know. We don't need to worry about the first sentence, the known knowns, which for our purposes are the issues we know about, we've identified them, and we know the answer. We also don't need to know about the last one, the unknown knowns, which are for our purposes are the issues we can't know about, even if we were to ask the right questions. Okay? There just isn't information available to know about these. That being said, we do need to make sure we ask the right questions while doing due diligence, because if the information would have been available, had the right questions been asked, then it isn't an unknown unknown. That leaves the second one, the known unknowns. And this is where we know there is an issue, because, but you don't know the answer. And this is where you really need to be careful, because you need to assess whether the unknown is something you can figure out the answer to and handle properly, or whether you need to tell your client that it's beyond the scope of your expertise and they'll need to consult with another professional. I run into these all the time. Simple example, I know that selling an investment property will trigger tax, but I don't know what that tax will be, and I don't have the expertise to tell the client, and I'm not going to guess. Okay, so I tell the client, and I make sure that they do this, to go to their accountant and get advice, because they need to know how much money they're going to have in their pockets. We need to have the right information on the forms. And I know this is an issue, but I don't know the answer, and I can't figure it out because I'm not an accountant. Sean, I'm almost done. So personality mismatch. Okay, we saw that in the survey, that problems with the client is a huge part of files that you wish you hadn't taken. So we can use the intake process to weed out clients or potential clients that aren't good fits, but we're not going to get it all. We're not going to get it right all the time. We're going to miss things. There's going to be situations where you accept a retainer and there's a subsequent breakdown and you can't keep acting. I'm not going to get into the details of this topic. It's a massive topic. You could talk about it for a whole day. Okay, but I have two tips. One, always be polite and civil throughout the retainer and conduct every file on the assumption that a third party whether it's a judge, assessment officer, the law society, or someone else, is eventually going to end up reading the whole thing. Okay, this isn't going to happen it's very rarely going to happen, but it does happen. And if you conduct yourself that way, you will avoid the situation where you send an email that's got some rude wording, even if it's just an internal email to somebody else in your office. I had one where one of the lawyers basically called the client an idiot in writing, and it wasn't directly relevant to the issues that he was dealing with as a defendant in a negligence case, but it certainly didn't help. Okay. So just, if you always assume that, I got to have a pristine file that doesn't have rude wording and, problematic things in it, you'll be okay. So just be polite and civil. And second, try not to let clients get behind on their accounts. I'm not saying this only because, you want to make money, but this will minimize the risk that you stay on a file longer than you feel comfortable in the hopes that you're going to get paid an outstanding receivable. And it will also avoid the risk that your client will complain about your work as an excuse not to pay what they owe you. If you let them get behind, there's a much greater risk that they're going to say, I don't want to pay you because you've been negligent. Okay. It's easier for them to say that than cut you a check. It's not as easy for them to say that if they've already gotten the check, if they've already paid. Finally, last slide, get help when you need it. Okay. I do this every day. I ask for help. I call them, I ask my partners, I ask my associates, I get help when I have questions, and I have questions all the time. I appreciate not everybody has the advantage of being in a larger firm, but as my colleague said earlier, build your network so you have that help. And Sean, thank you for a little bit of extra time. And thank you for having me.
Thanks very much, Michael. If I can offer some commentary on that ChatGPT, I will say that admittedly, we do have that many maple leafs everywhere in the law offices I have seen, but I'm not sure it's an appropriate depiction of Canadians to show us pointing and yelling like that. We're far too polite, but it's getting closer.
I think it's going to put Tim Hortons coffee cups in every picture. And anyways, I don't use it for work. Okay? Don't
Yes.
we don't know about privacy and things like that with it, but I like to play around with it. So Sean, thanks for having me.
Thank you very much, Michael. And just to reiterate that at LawPRO, we do give many reminders that if you are using any kind of AI applications to assist with your writing, please keep in mind that all research done through an AI service like ChatGPT needs to be double checked, because they will often provide you with false information, which can create a lot of problems. Now, I would like to ask Susan to join us as our final speaker. Susan, very excited to hear what you have to say.
Thank you. Much of what my colleagues have spoken about, I fear I will be repeating. But if it's not clear by listening to what Yvonne had to say and Michael had to say, let me be clear. Family law is a very risky practice area. It is not for the faint of heart, and it certainly is not for people who decide to dabble in it as one of the multitude of practice areas. It is not for dabblers, and it is by count the fourth area in which LAWPRO sees claims. So it's right up there. In addition to being a risky practice area, I believe that the provision of independent legal advice in the family law lane is an even riskier venture. The area in which I most see this, and Yvonne talked about this a lot, is in the domestic contract area. And you often have one party who is self-represented, and the other side to a domestic agreement is insisting that that side get independent legal advice. As Yvonne said, the domestic contract area is one of the riskiest in the family law lane, and these contracts are highly prone to being set aside. So when you're asked to give independent legal advice, there's usually a context, and that context is number one, you've got a self-represented person. Number two, I frequently see the expectation is that that self-represented individual wants to pay a very, very modest amount for the ILA. They're looking for you to tick the box. That should be of paramount concern to you. And these retainers should be considered and approached with extreme caution. Let me give you a few simple, very high level do nots. And these do nots are based on real life scenarios that I, as preferred counsel for several decades, have encountered, scenarios that Michael Zalev has encountered. Number one, do not give legal advice in a bar. Let me repeat that. Do not give legal advice in a bar.
I was kidding when I told you to say that.
No, this, no, I actually know where this has occurred.
I
I
do too.
also know, do not give legal advice casually to a friend. Do not give legal advice on an area that is outside of your practice expertise. So again, if you're a dabbler, do not give ILA on a domestic agreement. If there are some complex issues in that domestic agreement that deal with taxes or investment properties or estate planning, then do not give it. Do not give legal advice to someone where the other side of the contract is represented by a member of your firm. Do not give legal advice where your firm has acted for both parties to the contract on previous matters. Now, Michael talked about doing conflict search. The conflict search is at the outset of retainers. You must do a conflict search when you're undertaking an independent legal aid retainer. And that would catch things like, we previously acted for these parties, or we previously acted for the other side to the contract. Do not give legal advice if your client is unwilling to pay you the requisite amount for you to discharge your duties and obligations in connection with that independent legal advice retainer. And we'll get to what that entails in a moment. And then the number one thing that I see and do not do is do not consider that you have discharged your duties and obligations to give proper independent legal advice if you do nothing more than read through the domestic contract with your ILA client and then turn to them and say, do you understand all that? That is not what the duty of care is imposed upon you when you're giving independent legal advice on a domestic agreement. So Yvonne also talked about these issues percolate and often surface long after the facts, long after the fact of the ILA. I have a file cabinet, or now I guess a computer, filled with cases where the independent legal advice was given decades ago, and the couple has now decided to separate, and one party is waiving that domestic agreement, that marriage contract. I have cases where the lawyer who gave the independent legal advice has no file. I have cases where the independent legal advice lawyer is retired or even has lacked capacity at the time to even give evidence. So what does that mean? That means document your independent legal advice file thoroughly and comprehensively. Let me start with a retainer agreement. I think in the survey that Michael did, most of you have retainer agreements. I suspect when it comes to giving independent legal advice, the overwhelming majority of you would answer, you don't have a retainer agreement. Retainer agreements are always of critical importance in documenting what you're doing. And reference was made to Practice Pro. Let me just confirm, LAWPRO has the practicepro.ca website, which is the risk management program. There are phenomenal things on that. People should be accessing it. Just Google it. You'll see there's precedents for retainer letters, and those sample retainer letters you can use to craft or be the start of your ILA retainer letter. What should your ILA retainer letter address? Well, it should address the information that you need to complete your task, the scope of what you're doing, the associated time, of course, the fee and billing arrangement, and any limitations on the scope of the work that you're undertaking. So the file, in addition to having your initial retainer letter, which you need to explain to the client, should also have comprehensive notes, emails, letters, that sort of thing. The provision of independent legal advice on a domestic agreement should very much mirror what the other side has done, what the represented side has done in drafting that domestic contract. There is an intake checklist or a domestic contract matter toolkit on Practice Pro, which addresses a myriad of the things that you need to consider and turn your mind to when you undertake to give independent legal advice on a domestic agreement. So let's look at some of the non-exhaustive list of things that you need to turn your mind to. Necessary financial information and documentation. So what does that look like? Well, that would normally look like a sworn financial statement from both sides and the backup to support that sworn financial statement. One of the red flags that was identified earlier for setting aside a domestic agreement is no financial disclosure. The majority of the domestic contracts where I'm involved as either loss prevention counsel or defense counsel involve situations where the lawyer has given independent legal advice and there is no financial disclosure whatsoever. That is an absolute red flag, and you need to explain why complete and fulsome financial disclosure is necessary for you to give appropriate independent legal advice. You need to explain how equalization works and how the domestic contract varies the equalization regime and compare the two. So it's not enough to say, oh, so you see, you've waived so you've waived your right to equalization, or even so after 5 years of marriage, you get $10,000. That's not enough. You need to compare what they're getting under the contract to what they would get under the equalization regime under the Family Law Act. And if you don't know how the equalization regime works, then you shouldn't be giving independent legal advice on the contract. Likewise, you need to explain how spousal support works under the contract as compared to under the legislation. You need to also explain, of course, that any waiver of child support is not binding and cannot impact the child support, which is the right of the child. You need to also screen to ensure that your independent legal advice client is not being subject to pressure or duress. If there is a deadline looming, like the parties are getting married in 5 days, or a house is closing in 7 days, those are all red flags. And those are red flags that you need to pay serious attention to. Your file needs to be documented as it relates to the duress issue and the pressure issue, not only as it relates to the timing of significant events, but is the other side to the contract exerting some force or pressure. You need to canvass that, especially where, as I usually see, the contract is completely one-sided. So one of the parties is waiving all rights of equalization, all rights to support. That's a problem. That's a red flag, and you need to be aware of it. So you need to also explain that this agreement is potentially, and I say potentially, but potentially and presumptively final and legally binding. So they need to understand that there will be a significant hurdle in getting over this agreement. And so they shouldn't go into this casually or lightheartedly. It is completely acceptable, and you should, as a risk prevention step, decline these retainers where there is no financial disclosure and your client refuses to allow you to obtain a financial disclosure from the other side or from them. You should decline the retainer where the agreement is so completely one-sided. You should decline it when there's an event that is an obvious flag, like they're getting married in 2 days or 2 hours, or they've got that house closing. You should also seriously consider circumstances where your client will not allow you to negotiate any changes. So the best thing that I can have in a file where I'm defending a lawyer on a domestic agreement is a back and forth with the other side where terms were being negotiated. Remember, you are representing your client's best interest, and a one-sided agreement or an agreement slanted in favor of the other side should be negotiated. You should try for more, and the client needs to be advised of their right and their obligation, really, to see if they can better the deal. Where they're not prepared to do that, that's a flag. That's a flag. And they'll say things to you like, well, my husband has insisted it be this way, or my husband and I agreed to do this, and my husband's lawyer or my wife's lawyer has documented this in this agreement, but we've done this. This is a done deal. Those are all flags. In spite of your better instincts, there will be those of you who agree to assume such a retainer. When you're stepping into that very, very, very risky territory, you need to write an incredibly detailed reporting letter, supported by your notes, hopefully supported by emails or letters as well, but a very detailed letter setting out your strong recommendations for negotiating the terms, your strong, and what specific terms you sought to negotiate, but they refused to let you negotiate, your strong recommendations regarding disclosure, and that the client failed to follow your advice. In addition to that reporting letter, I would get the client to sign a waiver and acknowledgement, acknowledging all of those things. And you need to very carefully review that and explain that to them. You need to also take notes that reflect that you did explain all of that to them. And the other thing that I think you need to be mindful of is at the end of most domestic agreements, there's the certificate of independent legal advice. Look at what you're attesting to when you sign that, and make sure that the language of that certificate is accurate. Most certificates will say, you're satisfied your client isn't under duress, you're satisfied your client understands, all of those things. You better be sure that everything you put in your certificate is accurate. Finally, one of the things that you need to consider with respect to ILAs is the referral sources and who you might refer to. Again, it's not somebody in your firm if you're acting on the other side of the contract, and you need to make sure that these referrals are being made to someone who's competent in the family law area. You're not referring somebody to a real estate lawyer or a commercial litigation lawyer. it needs to be someone with practice expertise. And I see Sean is here, so thank you very much for the opportunity.
Thank you very much, Susan. And while I have you, I
Yes.
do have a few questions that I
Yes.
would like to pose to you that have come in
Yep.
from the attendees.
Yep.
The first is someone asking about family law mediators. And so if someone is acting as a mediator and not giving legal advice, is there anything that they should or can be doing if there's concerns about parties deciding not to obtain ILA, for example?
So, I do mediation in the estate lane and not the family law lane, but my partner's who practices only family law does a lot of mediations. First of all, the mediation agreement spells out that the mediator is not giving any advice or any and recommends that the parties get advice. But I think if you're presented with a situation where you're mediating with two self-represented individuals, it's the mediator's appetite to to engage in that sort of thing. The area in which we most see self-reps, I think, is where it comes to parenting as opposed to financial matters. But I would still recommend and urge the parties to get independent legal advice. One of the things that I, as a defense lawyer who doesn't practice pure family law, I'm always troubled by is in the family law mediation session, deals are always signed, and more times than not, very late at night. And those are the ones that I see, and Yvonne, I'm sure, sees where people are moving to set them aside. But happy to hear from Michael on this point.
Well, I have a couple other questions for
Yep.
you. I'll try to
Yep.
condense them into
Yep.
one thing.
Sure.
A lot of people did have questions about the condensed timeframes that you spoke to,
Yeah.
about the concerns when the wedding is coming up in a couple of days and suddenly there's a quick deadline and someone has to agree to something. One of the questions that we had is, what are the practical next steps? Now, I know you mentioned documenting any kind of external exigent circumstances that might be putting pressure on them, but is there anything else that you would say are the practical next steps?
I mean, frankly, I would decline the retainer. Okay. And if the other side, if the other side isn't prepared to agree to continue negotiation beyond the marriage date. So we'll continue negotiating, but we need a runway to do that. So that's what I would do. See if we can first extend the negotiation period, and we're not going to work to that deadline, period, full stop.
Would you ever do a standstill agreement?
Yeah. Yeah.
So that's
That's very common, standstill agreements.
That's an agreement. So if you haven't heard of it, where nobody acquires any rights as a result of the marriage for a period of time
To allow the negotiations.
Yeah.
Yeah.
And so then one follow-up to either Michael or Susan. Michael, if you want to jump in, feel free. But one person asked, if you are declining the retainer because of these kinds of circumstances where you feel there isn't enough time and there's pressure, is it appropriate to refer them somewhere else? But are you, you're just giving that problem to another lawyer then? What do you do in those circumstances?
I wouldn't. If I declined a retainer because it was too much of a mess and something that I was concerned was going to lead to problems, right, I wouldn't send it over to my colleague across the street.
Nor would I. And sometimes what I do, I'll say there's a list of certified specialists on the Law Society website. I can't refer you to anyone.
Or best lawyers
or best lawyers, or exactly. And then any one of those lawyers is going to decline that retainer as well. So,
but if you like, all of this goes back to the why. Why are we doing this? Okay, so why are we telling people I can't properly do a marriage contract 2 days before the wedding? Okay, there's reasons why, and if you understand those reasons, you know, basically the contract's going to be at serious risk later on. So if you're not going to do it properly, I tell people this all the time, do it on the back of an envelope with the two of you. It'll be just as enforceable as whatever you're doing with me. You don't need my sign off on it. You know, if they understand though the point, sometimes it's easier to deal with.
And Michael, we actually have a bunch of new questions now. Very simple, but perhaps a difficult question to answer definitively. But the question is, where should people go to find a standstill agreement precedent? Where would you recommend that? Unfortunately, I know that Practice Pro doesn't have a precedent for that, but that is something that we will look into because we're always building our library of precedents. But if you had to suggest somewhere else to look, where would you suggest?
You know, people can email me if they really need one. It's really, it's like you could take the divorce-made precedent and say, you know, the parties are getting married and they want to negotiate. They haven't had time to negotiate, and they're doing this agreement to negotiate, you know, to have additional time, and no one's acquiring any rights. But I'm happy to, you know, if somebody needs a precedent, they can email me. I don't think it's public. I don't think there's anything on DivorceMater that's on the web.
Okay. Thanks, Michael. One more question for you, Michael. This is in regards to those initial consultation meetings, specifically, I suppose, if there are red flags where you would be referring someone else out. One of the attendees had a question about how do you refrain from actually giving legal advice during those circumstances? The question refers to the fact that some people come in, they take an initial consultation, perhaps the initial consultation is free, and they're constantly trying to get the legal advice during that consultation. And so if there are these red flags, obviously that becomes a concern. What would you suggest is the best course of action in those circumstances?
Well, I'm a bit confused by the premise of the question because the purpose of the consultation is to give legal advice, right? The client's coming in, they're going to explain their problem to you, and you're going to give them some advice. You're going to say, this is, you know, what we need to do to figure out the equalization payment. This is what we need to do this is what support might look like. You know, this is what people often do with parenting. Try to identify any other issues. You're not meeting them just to say hi. You're meeting them. Like, I find it's actually the most valuable meeting I can provide is I can give them a pretty decent summary of what their case looks like, where it might go, what the options are, and what work needs to be done to get to the finish line, right? It's not just a meet and greet. So that I would reframe the question and say you are giving legal advice during that initial meeting. That's why I said when I spoke, you know, make sure you cover things like limitation periods and beneficiary designations, because if something happens and the client comes back later and says, well, I didn't know this, and you don't have any proof that you talked about that to them, or you didn't talk about that to them, you might have a problem because you're meeting with them to give advice.
Okay, well, thank you, Michael. Thank you, Susan. Thank you, Karen, and thank you, Yvonne.
Can I
That's
add
all
one
the time.
thing?
Sure, go
No,
ahead,
I'm
Michael.
sorry, I don't mean to go on. I
Thank
just want to say Susan is right. Okay, you should practice carefully and defensively. But you should also, if you go back, just to repeat what I said, if you go back and think about the why, okay, it's not just ticking boxes. It's why am I doing this? Okay, what is my job here? My job is my client's got a legal problem or a problem. I have to figure out a sensible and practical way to solve it. And I need to make sure that they understand the risks and they understand the options. And ideally, I want to be able to prove that they were told all of this stuff later if they come back and say I didn't tell them that. So if you're doing that sort of stuff, if you're doing the analysis, if you're taking the job seriously, if you're being really careful, because this is a serious job. It's, you know, when people come to you and say, well, why would it take more than 20 minutes to draft an agreement? I mean, that's ridiculous. The premise is ridiculous. You are doing a serious job involving potentially significant sums of money and people's children, and you need to take it seriously and be careful. It's not just, don't just, you know, slough it off and say, well, it's not a big deal. Think about it. And if you do that, you'll be okay.
All right. Well, thank you again, Michael, and thank you to everyone. We did have someone follow up to ask about Michael's email, and I'll just say, Michael, your email is on your webpage at Epstein Cole, and so if anyone does want to reach out to you, they can do so by going to the Epstein Cole website. Couple of more housekeeping questions. We're at 11:01, but if you give me 2 minutes, I just have a few things to say. The first is that there should be a link to a survey in the chat. If you could please click on that and complete the survey as initially mentioned previously. It allows us to develop these programs going on into the future. This program will be available to watch on demand at the practicepro.ca/CPD website in approximately 1 week from today. And all of our previous programs are already there available to watch on demand, so you can check out our previous content on different subjects. This program is worth 90 minutes of professionalism. There is no EDI that is accredited for this program, but we do have programs in the future and in the past that did have EDI components. And please join us for our next program, which is at the beginning of April. We will be sending out webzines to all practicing lawyers in Ontario through LAWPRO shortly, but that program will be on virtual practicing and doing elements of your case files that are happening strictly virtually, which we're all familiar with because that's what we're doing at the moment. Thank you for joining us. Thank you to the TLA, and thank you to all the speakers, and I bid you adieu.
Thank you, Sean. Thank you.
Thank you.
Good day.